feel free.
Yeah, that would, yeah.
Okay, I have 7:03. We'll call to order Zoning Board of Review for Tuesday, January 9th, 2024. The first thing we'll do, I'm going to make a adjustment to the agenda. If all members are in agreement, I was going to ask with the weather and 2 applications in front of us, if we would be better off just continuing the elections until the next ZBR meeting. If all are in favor, if I could have a motion to that effect.
I'll make a motion to that effect.
Second.
Okay, so the motion is to postpone elections until the next ZBR meeting. All in favor?
Aye.
Opposed? Okay, so that'll be, you'll get notification whenever our next meeting is. Roll call, please.
Mr. Najarian?
Here.
Mr. DeZiel?
Here.
Mr. Mostyn?
Here.
Mr. Macantonio?
Here.
Ms. Benoit? Here.
Item 3, disclosure of no compensation or pension credits received by board members. All the members are appointed by the town council. Item 4, disclosure and notice. Zoning Board of Review members shall disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before the Zoning Board of Review. Item 5, I believe all of you had received the minutes from the previous meeting on December 12, 2023. If there are no corrections or additions.
Only question I have, Mr. Chairman, is seeing that there's minutes for the Board of Review and the Board of Appeals, should we do a separate
We should
motion?
approve both, yep, that's a good
Okay.
observation. So we'll make the first one for the Zoning Board of Review meeting on December 12th, 2023.
Right, I make a motion to approve the minutes for the Zoning Board of Review meeting held on December 12th, 2023.
Second.
Second.
All those in favor?
Aye.
Opposed? And now we'll take a motion to approve the minutes from the Zoning Board of Appeals on December 12th of 2023.
I make a motion to approve the Zoning Board of Appeal meeting minutes for the hearing held on December 12th, 2023.
I'll second the motion.
All in favor?
Aye.
Opposed? Okay, thank you. Item 6 is the approval of the decision for ZBA 2301, which was BB-WW LLC. That was the appeal. That was sent out this morning, I believe. I've read it. It's pretty straightforward and doesn't appear to have lacking anything with respect to what was discussed. Are there any questions or comments or corrections? Hearing none, can we have a motion to accept the decision for ZBA 23-01 BB/WW LLC appeal?
I make a motion to approve the decision for application ZBA 23-01 for BB/WW LLC.
I'll second the motion.
Okay, all in favor?
Aye.
Opposed? Okay, and just for the note, it's the ZBA 2301 as opposed to ZBR, so that's why the
ZBA.
number is the way it is, which makes sense. Item 7, elections of officers, was just continued. Item 8 will be the continuation of ZBR 2311, application for a dimensional variance by Aaron Lawrence, 37 Lapre Road, North Smithfield. Applicant is present, right? Yeah, okay. If you could, so what we should do first, though, is introduce, we have some new information, so,
Okay, we left off at P5.
yep. All right, so P6, you have the full drawings, right?
Yep.
So P6 will be the variance plan prepared by Insight Engineering Services LLC, 501 Great Road, Unit 104, North Smithfield. It's dated 1/8/24. It's stamped by Professional Land Surveyor Mark Nyberg. That stamp number is 1797. Essentially, this is, so we'll get back to that in a minute, so we'll call that P6. P7, or excuse me, T1, we'll call it T1, Town 1. T1 will be the office, the letter from the Office of the Planning Board, Town of North Smithfield, which is addressed to Mr. Lawrence at 37 Lapre Road, with regard to the likelihood or unlikelihood of the extension of the paper road section of that street. So that's T1 and P6. You can take care of that, okay. Would you like to speak, please? So just introduce yourself again for the record.
Hello, my name is Aaron Lawrence. Live at 37 Lapre Road.
Okay, so walk us through. It appears that, well, we know we have the letter that we're calling T1 from the Planning Board, which appears to clarify that any extension of the paper road beyond your neighbor's property, which is downhill of yours, if you will, is highly unlikely, given the amount of wetlands in that general area. So, I mean, the reason that we had asked is to get kind of corroboration or the opinion of the planning board, which is the most relevant opinion, as to the likelihood, because as we had noted, that street being a dead end versus being an active road has significant implications to whatever this board may decide on your behalf for the relief that you've requested. So, so then you went ahead and you prepared, had Nyberg and Insight prepare the variance plan. So I know, as I had suspected, the entire house is non-conforming. Not only is the front in violation, but so is the right side. And then did you change the orientation of the proposed garage?
I did, because it would go 4 feet beyond the property line in the front if it had been running towards the street from the front of the house. So I rotated it 90 degrees so that it would be within the property.
So I think you can appreciate now that when we see a handwritten plot plan that says, well, it looks like 7 feet, we did that for a reason, for everyone's welfare, and if we're gonna try to do things right, then we should do things right, so.
And the additional modification is that the driveway goes off to the, I'm gonna call it the western side of the garage,
Yeah,
instead of just straight out to
out
the
on the
street.
street. And that's beneficial to the extent that you can park a vehicle without
Out
entering
in
the
the
street.
street.
Can
And
we tell on the big drawing as to what that distance is? I have both versions, but
If I had a ruler, I could probably figure
It doesn't show it, but if you just use the depth of the garage as a reference, it's probably
It's close to 30 feet.
30 feet, I would guess. So, because if you look at the setback, so,
It's
Okay.
30.8.
all right. I mean, the board has, in the recent past, approved expansions of a nonconformity. And I mean, and I think you can appreciate that that's the juxt of the issue. That is the core issue, that we have a pre-existing nonconformity, and we're being asked to grant an expansion of a nonconformity, and every aspect of what's in this book encourages us not to do that. But we have done it, and I believe many members on this board sat for that.
Right.
There is one, and to your benefit, and no doubt it was forced upon you by suggestion by Mr. Nyberg and the people at Insight when they looked at the reality of what you're dealing with and said, this is the only way you even have a chance. Architecturally, it's not our affair, so I'm only asking as curiosity because we all did see the elevations that you provided. Architecturally, if you reorient it in that direction, have you spoken to, is it buildable?
It is. So that was the plan B of my builder, was to go to that
Okay. He
configuration.
can adjust the ridge lines and whatever he needs to do.
Yes,
Okay.
yes.
All right. And I recall that on the School Street, and Vinnie, you made, the School Street app, which is the one that came to my mind,
That was 10 foot.
we steadfastly held to the 5 foot and nothing less.
Yeah, but what is the if you don't mind me asking, what's the dimension from the corner of the garage to the edge of the pavement?
It's 4 foot, 4
No.
point,
It's
That's
4
the
feet
lot
exactly.
line.
4 feet.
That's the lot line.
Well, we don't have that. We don't.
Do you know
we're
what
not
it is?
privy to that.
No.
Well, we
Not-
really
not from
can't,
them.
we can't accept it as hearsay. It either is or it isn't. The only thing that's relevant to us, honestly, is the property line, because that's the only thing that we can prove. And you're at exactly 4 feet from what is on the stamp plan, so that's what it is. I also remember that School Street was reduced to 13 foot 6 inches as opposed to 14 in width. Where, with this new proposed location, how are you accessing the vehicle from the house?
From an exterior door.
Which would be the common wall of the 22 feet with the existing house, or an exterior door?
Exterior door.
Okay. So really, all you need is the ability to open the doors on the vehicle, and you're not going to have a pass door swinging into the vehicle when you go to enter your house.
Correct.
Okay. Have you talked to your builder about how much tolerance you have on the 14 feet?
In terms of
The ability to reduce it?
the ability to reduce it, so servicing, working on the vehicle, it comes into play. Being able to remove axle shafts on it, everything, gives me the ability to work on it inside the garage.
So, I mean, of course, it's your right to do whatever you do, but so this garage is something where you're not just parking the vehicle, you might do minimal maintenance or whatever an individual mechanic trained can do with his own cars.
Exactly.
Okay. Anything further for the
Yeah,
applicant?
Yeah, I got one more suggestion. If he moved this garage up here, he'd have more than 4 feet. You know, if it was-
Yeah, the further it comes to the south, if
Yeah.
you will, or the left of the drawing.
Yeah.
But I think the problem there,
Because it's gonna,
well, architecturally, you still could do it. I
Hmm.
mean,
Mark,
because I think what Mr. Marcantonio is noting is that you know, it says right here on the drawing that the front setback is 25. Right now, if we were to grant you the relief based on the drawing you submitted, you know, that's a substantial encroachment, a substantial reduction. And it's our job, of course, to try to do as much as we can to not only satisfy a specific homeowner's request, but also to try to maintain some level of consistency in interpreting and in enforcing the rules that we're supposed to enforce. I think Mr. Marcantonio makes a very good point that that could be dealt with architecturally.
Yeah,
You
it's no
bump the
problem.
building out, you change the ridge line, or you do whatever your builder thinks he
Another
can do.
inside corner, that's all.
Yeah, it's not, you could conceivably put a pass door there too. So I guess the real question
This
is
one, to about-
for, we can ask, is there anything further of the
This is greater
applicant?
than 4 feet, you
I'd like to keep you there just for a moment, because before we go into deliberation, we really should kind of, the crux of the matter, I mean, we understand that there's two issues. The existing structure is non-conforming in two locations. So you can say, no, we don't want to expand a nonconformity. The applicant has worked with us to confirm with the planning board that it's essentially will remain a dead-end street, so that, and simultaneously, he reoriented the garage, probably driven by the reality that there wasn't a chance that it was gonna work. But either way, the vehicle, which was the primary concern of, if it were in fact 7 feet, the vehicle couldn't even exit the garage without being on town property. And we were concerned if it became an active road, we're creating hazard because it is at a turn. So neither of those issues exist. We don't operate with precedent, but we can't forget that we did something similar on School Street not too long ago, where
Right.
we granted that to a nonconformity.
Yeah, and the other matter that actually comes to mind is the matter that we had that was off of St. Paul Street, where the woman came in, she was adding a garage to
Oh,
the
yes,
back.
yes, Smith Place, yeah,
Right.
yeah. Elizabeth, off of Elizabeth, yeah.
Right.
But again, we can rely a little bit on precedent. We're staying in our lane just because it's our own working knowledge. But the real question would be as to whether or not we want to ask, following up on Mr. Marcantonio's point of how far the garage would need to be moved to the left of the drawing as you're looking at it to get as close to 5 feet as possible. If we were to ask the applicant to do that, it would be a continuance, and if he agreed, he would go back to Insight and have them
Even
come
if-
up with the
Right,
maximum distance where it worked there, you know, so really, that's where we are right now. You can say to us, no, I don't want to do anything, and then we'll vote, but I think it's clear that 4 feet is probably more than most members feel comfortable with. And of course, it just means a delay, but, you know, he could give you a couple options and say, if we move it 5 feet to the left, we're at 4.7, 4.8, 4.9, and 5. We're not going to tell you what we're going to do, other than to say to you that we have looked kindly upon 5 feet, but anything less is really pushing the limits of, well, why have an ordinance if you're just going to keep granting further and further encroachments? So,
Right. The only thing that possibly comes into play is that at the last meeting, I believe there was also a concern raised that given the
Turn your
length.
mic on.
Oh, I'm sorry.
Sorry.
I thought my mic is always on.
yeah, but you got to speak into it.
I also believe that there was a concern raised at the last meeting that given the length of the vehicle, that when they came out, whether or not he had enough turning radius not to encroach on the neighbors across the street. And having this long driveway addresses that issue. So if you move the building over westward, this is north, westward.
Yep.
You're reducing this driveway, and I don't know how feasible that
But
radius
actually,
is.
if I'm not mistaken, the abutter across the street is not directly across the street. He's
Correct.
about 50 feet
Further down the road.
further down. So you're not, you would be hitting a curb, right?
Right.
Directly across the street from you is either a curb or sidewalk or whatever. It's not a driveway.
Correct.
I remember going there, and it's about 50 to 60 odd feet down. So that shouldn't create
Okay.
an issue either way. And frankly, I don't know whether you'd need a curb cut. That's not our concern. You can work that out with whomever, but it's up to you. I'll put it back to you. I think you can conclude from the general attitude of the members that we'll vote on 4 feet, but it would be advantageous, much like it was advantageous for you to go to the planning board and go to Insight, to minimize, get as close to 5 feet as is possible. And then, have him, if you want, have him put a vehicle. He can probably do that. Let him superimpose a vehicle inside the
plenty of room there.
garage. But the bottom line is, I think if you're willing, we can go for a continuance, and you can go back to Insight and do exactly what I'm just suggesting, that you move it to the west or to the left as far as possible so that we can get as close to 5 feet or more as possible. And it would stand to reason that that would satisfy many concerns of the members.
One question I have is, would it be feasible to have it 20, instead of 14 feet, 12 feet, or is that too narrow?
The main consideration there was the turn from the driveway,
Okay,
having to be such a sharp turn. So that's where 14 feet was ideal, to have a 10-foot wide garage door instead of an 8-foot, which was part of the original proposal, because it was just straight shot out. Reducing it down to, from 14 feet to 13 feet, puts it 1.5 feet on each side of the doorway. That should be feasible to my builder, rather than extending the building to the left,
yeah,
where it extends beyond the house, because the ridgeline is actually going to maintain that same configuration on the house, instead of, on the original proposal, it was going to be an L-shaped
okay.
Yeah.
Because
house.
if we're looking for effectively 1 foot, that may be the best solution.
Right.
So clarify that again. Your builder had suggested what, or had mentioned that there was another option?
Well, if we were to, instead of being 14 by 22 feet, being 13 by 22 feet, we could still maintain the 10-foot wide garage door in that
In that
Oh,
instance,
well-
that would give the 5 feet.
Well, clearly, the 13 would allow you to keep, and ideally, then you keep it where it is. Okay. So he did say that if the builder told you that was viable, then of course the surveyor can just do as you instruct him to do.
Mhm.
So, okay. I guess, council, if we voted subject to, and we said we're approving or disapproving, subject to a plot plan being updated and submitted to the zoning official that accurately reflects the decision, as opposed to continuing this to get an updated piece of paper, is that reasonable?
You asked me if you can grant conditional
Yeah.
approval with follow-up by the applicant to
Essentially,
the zoning
yeah.
official to meet the criteria set forth, sure. You
Okay.
can do that.
So I think in the interest of expediting matters, knowing that we can require 5 feet, I think we're okay. Any other questions for the applicant?
Not for the applicant, but I guess for Mr. Archambault. Could we do a final approval conditioned on the structure being 13 by 22 instead of what's on the plan?
He's sitting on top of a pre-existing non-conforming use and asking you for dimensional relief, which is different than dimensional use relief. strike that, which is different than non-conforming use relief. You tend to have more discretion on the dimensional relief, as the chairman said, so you have the ability to limit the size of the structure and grant that as part of your approval. I would just base it in fact. If you're gonna make the decision that way, I would ground it in fact.
Yep.
Under the specific parts of, 9.1, so you lay it out properly.
Okay, so with that being said, what we could very well do is just approve what will be, not what is, on the drawing, and it would be incumbent upon the applicant to submit a drawing that confirms that. And that's between him and the surveyor. That would allow us to vote today, or tonight.
Okay.
Do we have anything further for the applicant?
I don't.
Do we have a motion to close the presentation from the applicant?
Make a motion to close the presentation.
Second?
I'll second it.
All in favor?
Aye.
Okay. Motion's passed. Is there anyone from the public that chooses to speak on this matter? Seeing none, we're going to close public comment on this application. A vote?
I'll vote to approve ZBR.
No. A motion to close public
Oh.
comment.
I'll make a motion to close the public comment.
Second?
Second.
All in favor?
Aye.
Aye. Okay. So we'll go into deliberation. You can sit. Thank you.
Thank you.
All right, so 9.3, variance approval standards, we'll go over these. And we should clarify that for the purposes of writing the approval, which is always in the affirmative, that's just the way we do it, for those of you who are new to some of our meetings. We have a list of criteria that we must review and justify to substantiate a relief. But as we write the approval, I think it's agreed upon that the basic issue here is that the closest, nearest setback for the proposed garage cannot be less than 5 feet. Whether that is achieved by reducing the width or the length is completely up to the applicant. But this relief, if it's granted, clearly states that the garage shall not be at any point closer than 5 feet to the property line. And I believe that goes a long way to achieve a lot of the issues that we had discussed. So 9.3.1, that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area, and is not due to a physical or economic disability of the applicant. We kind of went over all of this at the previous, but the house is on a small lot, as we can see now that we have the full-blown survey. So the characteristics of the subject land are unique in that regard. Of course, we know that a garage is technically not considered a hardship based on the state zoning handbook. But of course, every applicant, every landowner or property owner has the right to ask for one. And it's not, of course, this relief is not due to a physical or economic disability of the applicant, and not to the general characteristics of the surrounding area. You know, that street has many different sized properties, so you can't really conclude one way or another, so it doesn't seem that it's unique. It's unique in some respects and not in others. We did prove that it's a pre-existing non-conforming structure. Item B, that the hardship is not the result of any prior action of the applicant and does not result primarily from the desire of the applicant to realize greater gain. Clearly, there was no prior action taken, and there's generally speaking, when we're dealing with residences, there's no immediate financial gain resulting from the relief if it's granted. 9.3.1C, that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of this zoning ordinance or the comprehensive plan for which this ordinance, upon which this ordinance is based. You know, this one's always, can be problematic because it's so encompassing, but most structures in the area appear to be of a similar size, some with and some without garages when you drive down that street in the general neighborhood. Of course, the relief by definition makes it something different than the general characteristics of the surrounding areas, because you have to assume that all of the other garages are compliant, but we don't know that. And again, we noticed how well, it was a credit to that owner on School Street, you know, how well that came out. And we held to the 5 feet, and when you drive by there, even though the other house is far away,
But it don't look bad.
it doesn't, it looks like it was intended to be that way. It doesn't look like you shoehorned it. Now, aesthetics really aren't our concern, but it's just an added dimension that obviously we're going to consider because it's natural to do that. Item D, that the relief to be granted is the least relief necessary. I think we achieved that by getting the agreement from the applicant through conversation and discussion that if we hold steadfast to the 5 feet, then it's suffice to say that that is the least relief necessary to achieve the locating of a garage. Item E, that granting the variance requested shall not confer on the applicant any special privilege that is denied by this ordinance to other land, structures, or buildings in the same district. Again, this is another one of those that we need discretion and judgment. It would appear to be a special privilege because most garages in that general area do not appear to be that close to the property line or the pavement, whichever one the only one we can interpret is the pavement. But that's also kind of countered by the reality that we know, which is that it is essentially a dead-end street. It's the last house on that side, I believe. I don't think he has an abutter to the left. I don't believe so. We can check, but I can't ask him, but I don't believe that there's an abutter to the left.
And I'm sure there's probably other neighbors on that street that have garages.
Oh, many, yeah, you see them, you see them.
Yeah, we did one for Vadney.
What's that?
Remember that? We did that for Vadney.
Yeah, exactly. Yeah, I recall that. So you always have to weigh item E with the circumstances, and I think we did that successfully. 9.3.2A is a use variance that doesn't apply. 9.3.2B is in granting a dimensional variance that the hardship that will be suffered by the owner of the subject property if the dimensional variance is not granted shall amount to more than a mere inconvenience. The fact that use may be more profitable or that a structure may be valuable after relief is granted shall not be grounds for relief. In the eyes of the state, they indicate that it isn't more than a mere inconvenience because they think that garages are not, something that, quote, you're entitled to. However, we weigh that against the facts that are always presented in front of us, and given the fact that it's reasonable to ask for the relief to construct a garage, it would appear if you drive by there, I think I saw 3 or 4 vehicles on the right side. So It would appear that in this instance, it would be more than a mere inconvenience for the applicant. Again, the state premise that you're not necessarily entitled to a garage. But with all that said and all that weighed, it would appear that it would be a bit of a more than a mere inconvenience if the relief were denied. So, do we have anything to add to all of that information?
I think you covered it all.
What's that?
I think you covered it all.
Okay. Okay, now what we should also do, Mike, if you're gonna write the proposal or the motion, is to, let's make sure we get the application number correct. I assume you did that.
I did, yes.
And then note the
conditional approval?
the subject to, and it is conditional, that what we're stating essentially is the relief would be granted with the condition that the closest point of the garage shall not be more than 5 feet from the property line. Must be no more than 5 feet from the property line, whatever words you want to use.
Okay.
We could also note in that, if we wanted
No
to,
less than
that
5 feet, right?
no less than 5 feet.
No less
Correct.
What did I say, no more
More
than?
than-
Not to be closer than 5
Yeah,
feet to
exactly.
the
I don't know
property
why I'm
line.
paying attention.
Tomato,
to
tomato. Well, you had it anyway. We could ask, if you want, members want, we could ask that the plot plan, the variance plan be updated and submitted to the zoning official to confirm such. We can put that in there if you'd like. So when you're ready, if you need a minute, let me know. Otherwise, you can go ahead and make the motion.
Motion to approve application ZBR 2311 for dimensional variance by Aaron Lawrence of 37 Lapre Road, AP 006, Lot 202. Applicant is seeking relief from Section 5.5.1 District Dimensional Regulation of the North Smithfield Zoning Ordinance, and also zoning ordinance 6.9.8, that attached structures must be 25 feet from the property line. The applicant will be constructing a garage to the front of the existing house. Relief is granted that the garage is not to be closer than 5 feet from the property line,
With the condition that,
with a condition that the garage is not to be closer than 5 feet from the property line, and the zoning plan is to be updated and submitted to the zoning official.
you mentioned 5.5.1 and 6.9.8. Yep.
Yes.
Okay, and we had the number down correctly as,
ZBR 2311.
okay, good. Any discussion? Or do we have a second on the motion?
I'll second.
Okay, we have a second. Any discussion?
No.
I mean, I think that's concise. I think we're trying to do a reasonable thing, and I think the applicant has been cooperative and worked with us as best he could. So I know I think I'm satisfied that we've handled this in a fair and equitable fashion for the town and the applicant.
Yes.
We can close discussion.
Excuse me, Mr. Chairman?
Yes.
Should we do a roll call?
Well, I'm getting to that.
Oh,
yeah.
okay.
Yeah.
So we'll close discussion, okay?
Yes.
So with that being said, we'll call for a roll call vote, please.
Mr. Najarian?
Yes.
Mr. DeZiel?
Yes.
Mr. Marston?
Yes.
Mr. Marcantonio?
Yes.
Ms. Benoit?
Yes.
Good luck. Thank you for your cooperation.
Good luck.
Okay, if the public give us just a moment to gather push aside one bunch of material and pull aside in front the other.
Okay. Okay.
Yeah, condition, either the legalese.
here, I use my scale rule. Okay. He'll have between 19 and 20 feet to the driveway.
Well, close enough.
I know an inch when I see one.
Good boy, six.
Oh, there. I went to too many meetings today, and still paying attention.
No easy feat some days.
Lapre Road.
I gotta find my agenda. Okay, item 8 under new business is ZBR 24-01. Application for dimensional variance by Donna Corvo for the property located at 566 Providence Pike, North Smithfield. Owner of the property, Miss Jeannie Lemieux, is, this lot is AP 008, lot AP 008, lot 147. Applicant is seeking relief from section 5.5.1 district dimensional regulation to have less than the required 200-foot lot frontage and width, which requires a dimensional variance. This lot is RA zoning district. The applicant would be constructing a 5,000 square foot single-family dwelling. I think we need to correct that. That's 100, not 200, correct? It's just a misprint, but the frontage is 100, not 200. You agree? Is it 200? It should be, is it 200? Is that correct?
I stand corrected.
Yeah, it's 100. No, but I think the requirement is 100 feet, not 200. I mean, we show it as 200. Yeah, it's 100 feet. No, I'm just correcting the agenda. The agenda says 200 feet. It is 200?
I think it is.
Oh, all right, okay, my mistake. I was, okay. So it's 200. All right.
YMRA.
So first thing we'll do, let's introduce everything into evidence first, and then we can get on with things. So P1 will be the town North Smithfield Office of Zoning and Building Official. The complete form, which would be P1, and it's ZBR 24-01, is dated 1/9/24, and it notes the variance requirement, notes the planning board requirement, and again, it's the standard application with the attachment for a variance. That's P1. P2 is a letter dated December 19th of 2023. It's addressed, Dear Town of North Smithfield Zoning Board members. And it was submitted respectfully by Donna and Brian Corvo. And that addresses the contents of the application. P3 is the 200-foot abutters list, and that's 2 pages. It's dated 12/18 of 23, and it's caitech.com is the source. P4 we have as the 200-foot radius map. Again, same date of December 18th of 2023, also provided by CAI Technologies. We have a series of photographs are not dated, they're not marked. They're handwritten description on the bottom and sides, showing aerial views of the parcels and properties that interact with this application. But again, there's no date, so we'll call that P7. Also pictures of the proposed 50-foot driveway and the abutting properties left and right, it appears. So that's P5.
That's not included.
Not yet, I can get to that yet. P6 is a single-sheet landscape plan. It's drawn by a Diana Sewell Associates. It's not clear to read that, in Smithfield. It's a one-sheet partial of an architecture, of a landscape plan. There's no date on it. And it shows the landscape, proposed landscape layout for this 50-foot wide entrance or driveway proposed. P7 is a warranty deed with retained life estate and retained power to convey and hypocatate, don't know that word, sorry. P7, it was recorded town of North Smithfield on February 19th of 2013. That's a 3-page document. P8 will be what's titled as the master plan prepared by Darvo Land Surveying of Cumberland. It's dated September 29th of 2023. It's signed, stamped and signed by Michael Darvo, if I'm pronouncing that correctly. The signature date is 9/29/23, and the license is 1978. And then we have T1, which is the Town of North Smithfield Planning Board decision letter dated December 6th of 2023 with regard to this application. Before we entertain council, I assume, can we defer to our council? Can we clarify, are the rules of 2023 or 2024 applying to this application? It was submitted in 2023.
We're hearing the application in 2024. I mean, I'd have to really take a closer look to see if, because the application was submitted in 2023, that those rules would apply, but there's been no formal hearing. I mean, from a policy perspective, the hearing is commencing in 2024. All the rules have changed. It would seem to put an onerous hardship on the applicant if we were to go back to the 2023 rules, when the entire state of Rhode Island has changed it in 2000 to what's before you now, 2024.
But are we not doing that now if we continue?
Yeah, I mean, the applicant could argue that they submitted the application in time and were vested by to 2023. I think that's the position that the applicant would take, and that may be the best way to handle it. You agree with that?
I do.
Yeah.
Also, Mr. Rochambeau is a senator. I used to work on this legislation. Technically, the 3-2 vote versus 4-1 vote, that's procedural rather than substantive. So that is something that goes into effect technically at the time of the hearing.
Yeah, that's what, you know, that's exactly what I was getting at.
Yeah.
But looking at the big picture, putting the procedural aside, which is what I was talking about in the first instance, you are technically vested because you got the application in time, right? You agree with that?
I do.
Does that answer the question?
Well, it does, so I just want to make sure that we're proceeding properly, and the applicant clearly is dated in '23, so.
But we should follow the procedural rules that we are in now for voting and all, because that's where we are now.
We'll review that and make sure we get that right before we, there's so much information flying back and forth with these new changes. Counsel, if you could just introduce yourself again,
Sure.
or please.
S. Paul Ryan, with offices in Barrington, Rhode Island. Here for the applicant, directly and indirectly for the owner. Can you hear me all right on the recording? Yeah, you said okay. This application by Donna Corbo as the applicant and Jean Lemieux as the owner seeks a dimensional variance because the frontage is insufficient to meet the required frontage of 200 square feet, 200 lineal feet, in spite of the fact that the parcel contains 30.24 acres. The proposal, as noted, is to construct a single-family home on parcel A, which is, I highlighted the frontage so you could see that easier. On parcel A, and, but to access through a driveway the entire 30.24 acres with the 50-foot opening. Now, as the chairman noted, the planning board approved the master plan for the project, and the planning board also unanimously recommended approval of the dimensional variance for the insufficient frontage. Obviously, they had to make the approval subject to this board granting a dimensional variance for lot frontage. As obviously noted, one of the unique features of this specific property is non-contiguous frontage. Part of the frontage is here, part of the frontage is there, and in between there are 5 other lot owners between one frontage and the other part of the frontage. So that's certainly a unique character to this lot.
Excuse me, counsel, could you
Sure.
clarify that again?
If you look on the,
We see the 50-foot.
yeah,
and
the
then you have
50-foot,
To the right of the 50-foot is the 650 lot number. So where is the other frontage?
the other frontage is over here to the left.
Well, that's the other property.
No, no,
No,
this is,
right now it's certainly not.
No,
This
but I
is-
mean,
yeah, you mean subdivided.
exactly.
Okay, all right.
When,
Currently.
if the relief were granted,
Right,
just to clarify, I mean, we all can see that, but if the relief were granted, it's premised on the 50 feet that
Yes.
is highlighted right there with the,
yes,
and that is the only proposed entrance to the subdivided property if this moves forward.
that is correct.
While you're on that subject, is there any other, the planning board did make reference to something in the easterly direction, item 7 on the motion, that the applicant shall explore with our Rhode Island DEM possible relocation of the proposed driveway away from easterly boundary of lot 107 in a more lineal configuration in an easterly direction.
Now, that doesn't relate to the 50-foot frontage.
So can you clarify what
That-
does that exactly mean?
It relates to, if you see the driveway on the drawing, on your drawings,
Yep,
you'll see there's existing swamp next to the driveway. And so that suggestion by the planning board was that if DEM would allow the driveway to go closer to that swamp area, it would get it further away from not only lot 107, but the next one, lot
so it
108.
has no impact on the access from the turnpike?
No, whatsoever, none whatsoever. Now, in terms of the use of the property by the applicant, one of the things that you can't allow is a application where the financial gain is the primary reason for seeking the hardship. And in this case, placing a single-family home on the 30.24 acres of parcel A is probably the minimal use of this property, especially given the legislation that passed effective last week for affordable housing and other developments that would be much more intense. The legislation is aimed at making it easier to obtain zoning relief or DEM relief for such a project. In this case, we're only proposing a single-family home, and that's it. They actually could do a subdivision of X number of lots, which would also be much more financially rewarding than simply doing a single-family lot.
However, isn't it true that the 50-foot would be sufficient for a road?
Yes.
So therefore, you wouldn't need relief if you put a subdivision in there.
Right.
So
Yep.
I just wanted to make that.
Yep, good
make sure
point.
that's understood.
I'll agree with the chairman wholeheartedly on that one. So, let's focus on the 50-foot entrance for a little bit. The current, and those photographs were up a few minutes ago. I think you have the photographs in your packets. The current condition of lots 107 and 124, which are on either side of that 50 feet of access, is pretty open. And the applicant proposes to actually, as you saw from the landscaping plan, plant along both sides of the driveway, thereby screening the driveway from both lot 107 and from lot 124. And I'm suggesting that actually improves the situation for those two lots, given the way they appear now. The other issues related to my presentation relate directly to the engineer. So if I may call him, Mr. Chairman, unless you have questions.
Well, why don't you both, and then we can engage both of you. So, yes,
Sure.
please.
Okay.
Just identify, you know the routine, so the secretary can hear you speak clearly into the mic as you use it, please.
My name is Michael Darvo. I'm a professional land surveyor, president of Darvo Land Surveying from Cumberland. I actually reside at 9 Stone Ridge Drive here in Smithfield for the past 25 years. And I've been president of Darvo Land Surveying for 17 or so years. Prior to that, I worked since the mid-'80s for a gentleman this town has known, Bob Canoyer. And previous to that, I worked for the city of Woonsocket for a couple of years. So that's my background. I can give you more details if you like, but
I think that's sufficient. Thank you, sir.
thank you.
You can add, do you have anything to add specifically to
Yes,
the
he does.
presentation?
Yeah,
Okay.
he does.
So I was hoping to have the board, but with technical difficulties, we'll go with old school, if that's okay.
We all have it.
No, but I mean, you can pass mine around.
Oh, fantastic. Does this work? Oh, fantastic. So,
Members, members of the public, you want us to move that so you can see it? Yes. We're happy to do it, because we all have one, so if you can move that plan so that the public has sight line of sight.
Whoa, whoa, whoa.
how's this?
Whoa, whoa, whoa.
Okay. So briefly, I think the basics of the property were identified as far as size and so forth. There's about 4¼ acres that has been identified by Scott Rabideau of Natural Resource Services. It is shown on the plan. I'll just generally highlight it here from my plan. Coming through the property here, narrows down, comes around, and it goes north and then turns westerly, and it goes into a 24-inch drain line under Providence Pike and then continues west somewhere. There's other drainage from Pound Hill Road area that kind of flows into this wetland also. So the majority of the wetlands is, unfortunately, right smack opposite where the 50-foot entrance is. So on our plan for proposed development, when we come in from the 50-foot access for this new parcel A, we bang a left and we bang a right, and we kind of come around to where the proposed building is on the back of the wetlands. The reason for the snaking of the driveway is that DEM, who has to review and approve this, is going to want minimal impact to the wetlands as much as possible. And going straight through the widest part of the wetlands is not minimizing the impact to the wetlands. So they would like to see less disturbance into the wetlands, wetland buffers, and so forth. And we feel that a combination of the slopes of the property, the amount of wetlands, the location of the wetlands, and so forth, this provides the best access for the location of the dwelling to the rear of the wetlands. I do want to note that on the site, there's varying topography. It starts off at an elevation of about 300. It goes up from the road about 30 feet to where this property actually starts. And then it drops back down to the wetlands another 30 or so feet. Then it climbs up to the tip another 150 feet or so. This is, I call it the backside because I live off Woonsocket Hill Road, but this is the side off of Woonsocket Hill, actually, right?
So if you could, Mr. Darbo, it appears, if I just look at these topos quickly, it's about a 70-foot differential between what would be, say, finished floor of the proposed dwelling and the driveway at Providence Pike. Is that reasonable?
Yeah, you're about 330, and, well, it's about 30 feet difference.
30 feet.
Actually, yeah, but it's going to go up, down, up, and so forth, right? It's rolling terrain in that area.
I also noticed, I didn't see any, not that it, and again, it's not relevant to us, but it's part of our general questioning. I don't see any proposed location for a well.
So
Is that a concern with the wetlands?
it's not a concern, minus, this parcel's 30 acres, minus the 4 acres of wetlands, we got 28 acres to play with, so to speak, right? So it's my opinion that there's 3 possible areas that are fairly level that would make a great spot for a potential building and so forth. One is the one that we show. There is a couple others on the site and so forth. My opinion is that with today's technologies, I'm not worried so much about a well, because I think there's a lot of water in town and so forth compared to, most of my work is in South County, which is, wells are a premium down in that area. Here, I think that we're not gonna have a problem with septic systems either, not a problem with ledge, water tables, the soils, and so forth. Today's technologies allow you to put septic systems almost anywhere with today's DEM rules. So I'm not too concerned with that. I think, in my opinion, there will be a spot on the site that it can be placed, and that will be able to, accommodate those building requirements. So I didn't really show a tiny spot that would be a well on this 100-scale plan of 30 acres. So it was more concerned to show the location of the proposed driveway. Now, the driveway, there was a lot of discussion at the planning board meeting. I've shown this as a 20-foot wide driveway. I've mentioned that DOT is going to have a look at this because Route 5, Providence Pike is Route 5, state highway. they're gonna have some specifications, some concerns that we're gonna have to meet for their requirements. I'm sure public safety is gonna have some concerns on this also that we will have to discuss with them. DEM is gonna want us to minimize the impact to the wetlands, which kind of means make it as small as possible, less fill, less grading, and so forth. So we're going to take all of the concerns of everybody involved and come up with the best solution with what will work for public safety, for DEM, and so forth. So there's a number of hurdles, a number of steps, obviously, should this even happen after tonight or in the future, that people will be looking at this project and making some approvals and, and so forth.
To the eye, when you're driving by briefly, am I mistaken, or did I see that there's a noticeable drop in elevation, maybe 50 or 100 feet back from Providence Pike?
Yes, so when you drive by, there's the two buildings at 650 and 630, we go in between there. That's relatively level to the back of those properties. Then it does drop down about 30 feet or so where the wetlands are, in the wetland buffers and so forth. Then it goes up again and so forth. So yeah, there is a drop and whatnot. Some other items that I wanted to mention. There was a question earlier about comment from the planning board in regards to a possible driveway access off of near the existing dwelling, which is about 1,000 feet away. And my comment or my answer to that is that right along where that driveway should be, there's an AT&T easement for
Natural gas.
yeah, it's an underground cable. My experience with underground cables of that type aren't 20 feet deep, right? They're just as deep as needed. And if you look at the topography where that driveway would probably have to be, again, there's a 30-foot high slope, and then it drops down 30 feet again. To put a driveway in that area probably is going to require some cuts and fills, which is where that easement is. So I think that we're going to get some pushback from AT&T on doing anything within that area. It is something that DEM will explore. They'll look at all options to, again, minimize the impact to the wetlands, and that is something that we'll have to discuss and talk to them with it. Whether the driveway is near the house or here, the legal frontage, should this happen, is still going to be the 50 feet located further south of the existing house.
If you could, is that what the planning board was referencing when they indicated, quote, will not interfere with underground utilities? Somewhere in the decision, I didn't write down the exact, but there is reference to that in the planning
I
board
believe so.
decision. Okay.
There's no real other underground utilities in the area, right? There's all poles on Providence Pike, overhead wires and so forth, so I believe
And then,
that's...
if you could, another question, which is probably for both of you, or whomever. Item 6 of the finding of facts, that the applicant shall confer with NSFD, the fire department, and the DEM to determine a sufficient driveway width to accommodate public safety apparatus and result in the least disruption to the existing wetlands. I guess one concern I have is, before you were to seek relief from the zoning, wouldn't it not be wise to get that determination first? Because if this board were to grant the relief and then the fire department and the DEM says, no, you can't use that, then you're gonna have to come back for additional relief. I mean, it just seemed to me counterintuitive that you've acknowledged clearly that there are some issues that you are anticipating the DEM is gonna raise, because we've all been in this side of the table long enough to see how wetlands impact development. Clearly, wetlands have a significant impact on this property. So, was there any consideration by council or by the engineer to go and talk to them first? I understand the pecking order, but,
We went to DEM, in answer to your chairman's question. But a preliminary determination is not binding on DEM. So whatever this board decides, if they grant approval, is still gonna be subject to DEM approval. We just can't avoid, and if they changed it, we would have to come back. We know that, is what I'm.
so you can't, for the record, you can't rule out that there is a probability or a possibility that they may say, no, we don't want the location there, we want it, like you said, 1,000 feet plus or minus down near, and you have to deal with that easement and utilities and what have you.
That's correct.
Okay.
Yep.
Yeah, so for the, Scott Rabideau did have a meeting with DEM. It was a question of the planner before what the process would be, if it could even apply and so forth. And that's been squared away, that the logical steps, or not the logical, but the actual process was master plan, zoning, then we go through and make all the formal applications to DEM, DOT, et cetera, get all of our permits and other approvals in place, then we go through and get the final, preliminary and final approval from the planning board.
Okay, thank you.
In a nutshell, I think that's my presentation.
Okay, I mean, if you could both stay there for a moment. I know I had some questions, and for the public, just so you understand, again, there are many nights we sit here and it's just the chairs. So when there's an application that for better or for worse, whatever reason you're here for, the way we do it is that we listen to the applicant, because they have the right and the privilege to tell us what it is that they want. We engage them because they're the professionals, be it legal or civil engineering side. And then we will give you an opportunity to speak. Whether you're for or against isn't relevant to us. You're welcome to speak, but that will come after we engage them. You can, and when you speak to us, you don't speak to them. And we'll leave their discussion open, so if you raise a question that we didn't see, then we'll ask for follow-up. But that's the one thing to ask for your consideration is always, of course, be respectful, be concise with whatever it is you're going to say, and address us. And then we will address the applicant if there's something relevant that you mentioned that we didn't see. Okay? So we'll get to you. One thing that just keeps hitting me in the face is that I'm a little bit confused. The planning board essentially is saying that through their decision, even though they acknowledge it here, that they are creating a non-conformity. I mean, I had brief interaction with our council, but am I wrong in stating that essentially this action that the planning board preliminarily approved, your decision, creates a non-conformity that wasn't there before?
It does, but also, I've had a non-contiguous frontage case in Massachusetts that went to the court system. I'm not so sure that it's in conformity now in terms of frontage, with that split frontage. If it were contiguous frontage, I think it would be no problem. But the non-contiguous frontage may in and itself be because in Rhode Island you can't piggyback the numbers. In Mass you can piggyback the numbers for frontage.
But we took what appears to be happening here, and I understand the logic, and I think members do too. I mean, but the logic's a little bit different than,
I understand.
we take one very large lot and lopped off the part that has the existing house. And then by definition, because this probably was planned as a subdivision at some point, therefore the 50-foot driveway, instead of it becoming a subdivision, we're creating a nonconformity and asking it to be a single-family home, and therefore we need the relief. But then that leads me to question number 2, and again, as council knows, we have to go by the criteria established, it appears that the hardship is a result of a previous action, because the hardship didn't exist prior to the lot being subdivided. So I'm confused as to how do you define the hardship if I'm missing something?
The hardship doesn't, it can't spring out of a planning board approval. Have your own counsel get in. So the hardship is what was the condition of that property at the time application was made to the various regulatory authorities. Not what its status is as it's going through the regulatory process. So,
So what is the hardship?
the hardship is that, literally, the hardship is that to build a single-family home, you need to have the more limited access. To do a subdivision or a affordable housing project, or probably a solar project, as you pointed out, you don't even need any relief. But the hardship status is at the time you make application to various regulatory authorities. DEM doesn't consider that an approval here, in effect, you fostered the hardship situation. They take it as it was before it was started and look to see if it meets their regulatory scheme.
But I guess, depending on what glasses you have on, no pun intended, but it's clear that I think everyone agrees, and I respect and I understand what the current owner and the proposed owner is trying to do. But essentially, I think it's clear that if there wasn't such extensive wetlands on this property, it would be ripe for a subdivision, which in fact it's zoned for. And the 50-foot would be plenty enough to put a road in, and all due respect to abutters, if there were no wetlands there and it was pristine property, it's zoned for a subdivision. You wouldn't be here, you'd be at the planning board, and whether we like it or not, they would approve it. So really, it appears that what we're trying to do is give value to a piece of property that doesn't have any, because it can't be sold for a subdivision, and we're trying to put a single-family lot there. In essence, we're asking for 150 feet of relief, right? Because we're going from 200 to 50?
In theory, but getting back to the new statutes, of which I represent some affordable housing developers, frankly, the fact that you have even that amount of wetlands would be a little hurdle to do an affordable housing project on this property.
Okay, so then there's another use if.
Yeah, you're gonna get density that'll vastly exceed the density of a subdivision. And you're gonna get it with the legislative intent that it be approved, the statute.
Mr. Chairman,
Yes.
I don't think there's any question that that's absolutely correct. You could go and you could put a road in there with planning board approval and put in a higher density development. He's
Yeah.
telling you he doesn't want to do that, but they could. They
Yeah.
could put, which I'm sure none of the neighbors would want.
Well, but I just wanted to establish for the record that
No, that's,
in effect, I mean, we understand the logic, but we can't deny what's staring us in
oh
the
no, I
face.
understand, but I used to be, say, the Bay's attorney for 30 years, so that amount of wetlands is, from an engineering standpoint, he's the engineer, it's a doable development. It may be a max out, as a regular subdivision. It may not be a max out subdivision, but it could be a subdivision.
Okay. Members have any questions for the Attorney Ryan or Mr. Darvo specifically? Okay. I think we want to keep it open for both of you, and we'll just table it for now so we can give the public an opportunity, and then we can re-engage you if they raise specific issues that we want you to clarify.
Thank you.
Okay, thank you, sir. Are there members of the public that choose to speak? You can raise your hands. I just want to see how many first, sir. So we have 3. It doesn't matter what order you go in. This gentleman had his hand up first. Okay. When you come forward, if you could, just speak clearly into the microphone, give us your address and your full name, and then be as concise and brief as possible. Thank you, sir.
Hi, I'm Frank Kalenko. I live at 600 Providence Pike, which is on the short map that we see in front there. I was at the planning board meeting, and there was discussion on the AT&T fiber optic communication cables, and there was no information on them at the time, and it doesn't seem like there's any other additional information at the time. I mean, on today, as to what would it take to put a driveway across those cables. And
To the left of
to the
your
left
property.
to move the driveway.
Yep.
And it just seems to me it would be prudent to run that investigation as to what it would take to come in through that route.
Is that your preference? Is that your concern?
I just think it would be a prudent thing to do. I'm solely for having this done. I think it's a good idea. I don't know if it's the best way to come in through that way or to come in through the other way. But I'm definitely in favor of instituting this.
Okay.
So
And as I understood, both the engineer and the attorney, that they're going to be required probably to engage, they are required to engage DEM, and if DEM decides that that is what they want, then that's what would be done if this relief is granted. So we can only rule on what is in front of us. I don't believe we have the right to say to them, you must move it to the left. I guess we could, but really that's not our first line of action, because that's not what we're being asked to do. So, okay, thank you, sir.
thank you.
Next.
Good evening.
Sure. How are you?
My name is Jamie Salisbury. I live at 620 Providence Pike.
Pull that mic a little
There we
closer,
go.
please.
Well,
Thank you.
I live to the second house to the left of where the proposed driveway is going to be. I'm in favor of what Mr. Kay was stating about possibly putting the driveway over by 566. Honestly, mind if I approach this?
Go ahead.
I know this is the data line for the underground wire. There's no reason why they honestly couldn't put a small bridge up and over. I'm thinking more or less, you're gonna go up and down, no matter it's up and down in elevation, which is this side or this side. Me personally, I'm thinking straight in this way. I think would probably be the less of an issue for the wildlife, because you're avoiding the swamp here. You have a little bit here, but not as much as you're going around. I mean, if they did that, hey, by all means, you know, I have no problem with them whatsoever. They're very nice people. But I'm thinking that would probably be a better idea, especially for where we live. You're gonna have it all behind our property, and
So, Mr. Salisbury, is that your greatest concern, is the approach road as it's drawn?
as the approach road is drawn, yes, it's my main concern. I mentioned before about the well, you know.
No, I missed that, I'm sorry.
Yeah, I was at the planning meeting, so.
So the well is,
The well, it's, your first corner is directly behind my property.
yep, and your well is to the rear of your, near the
Yes.
property line in the back?
Yes.
Okay.
So my main concern is, oops, something happens and now I have no water.
Mhm.
Then you're dead in the water. On this side here of the property, is this another piece of property for the engineer?
Well, no, you can't, we'll ask him that.
it's not, does Woonsocket Hill Road go over here? Would it be easier to go that way?
We can
Probably not.
ask,
That's probably
yeah,
why they did it
we
this way,
we can
but,
ask them, we can ask them.
But yeah, I'm just, that's my number one concern for that.
Okay, thank you, sir. Next.
My name is Raymond Dion. I live at 491 Providence Pike. I'm not within the 200, but I am just up the street from the property. And I vote in favor of this development. The simple fact is that you've got 30 acres and you're going to put one house on 30 acres versus multiple housing. And I think that's a win for the town and a win for the property owners as they are now. Thank you.
Thank you. Anyone else? Okay, if no other members of the public choose to speak, we can have a motion to close that portion.
I'll make a motion to close the public part speaking.
I'll second.
All those in favor?
Aye.
Aye. Opposed? Okay, so why don't we welcome back counsel and engineer, Mr. Darvo. Can you address Mr. Salisbury's basic question about what is that property, if you will, here? That's inaccessible? Sorry.
Well, it's a different owner. It's another property.
Yeah,
It's in
so
a butter.
there's no access
There's no
to
access.
anything.
That's not Woonsocket Hill Road. It is, God, I'm drawing a blank. I'm sorry. Yeah, but it goes up to the cul-de-sac, way up top of the hill.
Oh, all right.
But whatever the
Not
case,
Brentwood,
it's,
what's the
you're
other
going
name?
on private property
Yeah,
at that
yeah.
point, so it's
So-
not relevant.
And this piece, after this piece, there's frontage lots on that side road. And I apologize, I drive by it every day, I don't know them, don't remember the name. But it's the long cul-de-sac that goes up to the top of the hill. And there's houses there, then there's this larger piece in the back, and then there's us. So there'd be a long distance and a number of properties that are not part of this.
Yeah. As it relates, all three members of the public who spoke indicated that they were in favor of the project, in essence, for the clear reason that it's the the single residence as opposed to any form of a development, whether it's allowed by ordinance or not. But they all voiced the same concern, which is, or two of the three at least, moving the access road to 566. A basic question, I guess, that comes to my mind is, looks like that frontage is 140 feet, is that correct?
There's about 217 foot.
So you got the 76 and the
Yeah, there's some
100 and-
angles in the road and so
Okay,
forth.
so in total, it's, okay.
Roughly 217.
And what would you need, in the event that the DEM, if they pushed you to that location out of necessity, what would you need? The same 50 or to do the road and the buffer?
I can't give you a definite answer. We haven't studied the grading that would be needed, right? From the road to the top of that hill along the property line, which is where the access would be, I believe is about 30 or 40 feet of difference in height. So that would mean some significant cuts and/or fills.
Retaining walls.
Or something, and that's where that AT&T is. So aside from the AT&T, just the grading that would need to be done to get a driveway through there, I think will be significant. So either retaining walls, or when you do 3-to-1 slopes, that starts dragging out to a large surface area, which will impact the wetlands that wrap around to where the 24-inch pipe is that goes under Providence Pike.
So the path of least resistance is what the relief you're asking for?
That's my opinion at this time, with everything that we've studied, the discussions that have been made with DEM. You know, they're looking for the minimal impact to that area where there's less up and down grading and cutting and filling that'll need to be done, et cetera, et cetera.
And counsel, if you could, for the benefit of the public, we understand that, you know, if relief were granted, all you have is preliminary master plan approval, they are more than welcome to attend, if you are granted the relief, the additional planning board meetings where the issue of how you protect your well and how you, all of those things are flushed out at that time through those progressive approvals.
I had suggested to the abutters at the planning board master plan that they definitely should contact, especially with the well issue, they should contact DEM directly and point out or present their location of their well. So it's in the DEM record when DEM's reviewing this application. They can't just rely on the fact that DEM would know the location. I mean, they've got the records, but they're not gonna look through them. So I implored them to get their relevant information as to relate to a DEM application to DEM regarding any approval that we might get.
Okay, thank you, and that's, important, so they know that no matter what this board does, they still can actively participate in the process as it.
Oh, absolutely. Both at DEM, although DEM doesn't have the hearing process that they do here. So the next hearing would be the preliminary at the planning board where there's public participation and comment.
Okay,
If I could
Sure,
just
go
add
ahead.
One more item. As far as DEM, I believe that this application will have a public comment period
Right.
from DEM's review. It's gonna be up to that level of disturbance to the wetland and the buffers and so forth, that probably DEM should be sending you some notices. It could be 6 months from now, it could be quite a while from now, but I believe it's gonna be to the level that it's gonna have public comment.
And I was curious for the record, I mean, we can say it only because we had members, owners at 600 and 620, but apparently, if the owners of 630 and 650 are present, they chose not to speak, so, we didn't hear from them. Okay, do we have any further questions for either council or the engineer? Are we okay to close the presentation of the applicant?
Yes. I'll make a motion to close the presentation by the applicant.
Second?
I'll second it.
All in favor? Aye.
Aye.
So we'll go into deliberation. For council, our council, I guess, I understand, but, the ZBR has the right or the authority to do many different things within the realm of its discretion. But it just struck me, I understand exactly, and I think members do too, the intent here. And it's hard to argue. My only clarification for posterity and for formality is, we are in essence creating a non-conforming lot. But the planning board is approving that through their action and their decision letter. So is it up to the ZBR to defer or to just make their own decision either way? Because our ordinance clearly says that the intent is not to expand upon and/or create a nonconformity.
I think you need to rely on the planning board's finding that there's preliminary approval in this at the master plan stage, subject to your granting of the dimensional relief, and that, as counsel said earlier, Mr. Ryan, the planning board can't grant relief that, or approvals that create a hardship. There's case law against that, Supreme Court case law, you can't do that. So by the planning board granting its initial approval of the project, subject to your relief, I don't think you need to worry as much about the nonconformity of the lot. I think the bigger picture here is you have complete discretion within the application for the variance to deviate from the 200 feet if you choose to do so. And I think that the policy points that the attorney pointed out with respect to the fact that there could be a solar development or a larger density development, and then the input from the abutters would be the factors that I'd weigh. into 9.3 when you're making the decision. So I wouldn't worry, I know you're gonna do all that, because I know how sharp you are with these things, but I wouldn't worry about the nonconformity because you have this master plan approval from the planning board. It's more of a policy, it's your town, and what do you guys think is, you know?
And in essence, just as a quick follow-up, I did ask Attorney Ryan, and he did respond. So the hardship, if you will, is post, not pre. After the lot is subdivided, the hardship is the 50 feet. It's not hardship because you created it, but it's now a hardship because the lot would be created and there's only 50 feet of frontage.
Yeah, and I think
Well,
you
the
can.
hardship is you can't use the property if you don't grant the variance.
Yeah, exactly, Chris, exactly. And I think when you go to make your decision and you put that into that tentative relief, that you phrase it that way.
Okay.
Yeah.
I think it's important for us to get, a legal
Sure.
understanding so that
You're not creating this second layer of some
Yeah,
hardship.
and
by
I
any
think we
relief
want to
you
be
put
fair to
on.
everybody, and we don't want to start creating things that are way out of bounds, but we want to be fair. So, okay, thank you. 9.3.1, that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area, and is not due to a physical or economic disability of the applicant. We kind of flushed out how we should define the term or the word hardship in this regard, and the way I understand it is that, and I'm comfortable with it, that the hardship comes after. So we created the subdivision, and the only way to access the larger parcel is through the 50-foot, and therefore that's the hardship. And it is unique, clearly, because it is the only access to that, that lot. So I think it is the hardship, if we use that premise and that definition, it is due to the unique characteristics of that subject, land, no structure in that side, and not to the general characteristics of the surrounding area. And we clearly can see that because most of those parcels and properties are almost dead level. When you're driving down Providence Pike, you don't see a lot of significant hills with residents on them.
And the only thing I might add to that, Mr. Chairman, is to the extent that what's on the record, it appears is that that 50-foot segment of land heading towards that back lot was always intended to be the area of ingress and egress to the property.
That's a good point. Clearly it was by the way they laid it out, whether it was to be a subdivision or in this case, if the relief is granted, a driveway essentially. Item 9.3.1B, that the hardship is not the result of any prior action of the applicant and does not result primarily from the desire of the applicant to realize greater financial gain. My initial response was other, but we've flushed that out again, and we realized that the proper interpretation is that the applicant is not creating a hardship, but the hardship is a function of the action of subdividing. And the issue of financial gain, again, it's a single-family residence, so you're hard-pressed to say that that it's primarily from the desire for financial gain. Item C, 9.3.1C, that granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of the zoning ordinance or the comprehensive plan upon which this ordinance is based. It's a very subjective, as it usually is, analysis and interpretation of that sentence. The 50-foot variance essentially wouldn't alter the general character of the surrounding area because it would just, in essence, be a driveway. that's pretty clear from the engineer and from the topography that you likely would never see the home when it's built just because of the elevations involved. So all you're gonna see is a paved driveway to the uninformed. They're just gonna think it's a driveway to wherever. And the planning board, in their decision, they reference two land use goals, 1 and 1.A, which are somewhat subjective or self-serving. I think they had to find a way to substantiate what they were doing, but that's their, that's their reality. Then there's some reference to sewer and water, but that doesn't seem, it's pretty clear that what this boils down to is that the planning board can find rationale in the comp plan. But I think also when this board looks at what the intent of the zoning ordinance is, we had abutters all testify in favor of this. We had no one speak against it. The qualifications or the concerns of the abutters, I think, were clearly received and acknowledged by the applicant through the attorney and through the engineer. And they already acknowledged that those issues may be presented to them by the DEM out of necessity. That wasn't their path of least resistance, but that's where they may have to end up. So that's all in flux and it'll be flushed out. So I think that granting the variance, although it will not alter the general character of the surrounding area, and it is, for the most part, clearly you can find that it's in, the purpose of the comp plan is met, and when we qualify our zoning ordinance to reflect the reality of what we're looking at, it would appear that it's consistent with that as well. D is fairly straightforward, that the relief to be granted is the least relief necessary. That's pretty clear that it can't be less than 50 feet and achieve what needs to be achieved. E, that granting the variance requested will not confer on the applicant any special privilege that is denied by this ordinance to other land structures or buildings in the same district. It appears that most properties are in compliance with the frontage, but again, the special privilege in this instance is a function of the uniqueness of the parcel when it was subdivided, that there is no other means, so therefore it's really not a special privilege. It's a function of necessity. Item 9.3.2A is not applicable because it's not a use variance. Item B, in granting a dimensional variance, the hardship that will be suffered by the owner of the subject property if the dimensional variance is not granted shall amount to more than a mere inconvenience. The fact that use may be more profitable or that a structure may be valuable after relief is granted shall not be grounds for relief. Clearly, I think the threshold for, quote, mere inconvenience is met, because if the relief isn't granted, that parcel becomes inaccessible and of essentially no value, unless, if we were to vote against, yes, there is another use, which would be a subdivision of one form or another. So that, again, that's a couched reference to a mere, in this instance, in this application, it's more than a mere inconvenience, but in truth, if the board were to deny the relief, there is another use for the property.
And it also ties into the category of the
Yeah, you can put in more
least
homes.
amount of relief requested, because they're only going to build one house. on
Because
the
you
property.
can look at it that way too, yeah. And there's a benefit to that. And what isn't written here is, some of the sentiments of the abutters who spoke, which is they clearly are of the opinion that they'd rather have one house than any form of a subdivision. Oh, I can't do that. We're in the middle of a meeting. All right, so are there any other additions to those summaries?
No.
Okay. I think probably what we should do is, we can if we want to. I don't know if we need to. Do we need to make mention of the idea of the applicant further investigating relocating the entrance, or we just leave it be and let the DEM and everyone else flush out there?
I would leave it be.
Yeah. Everybody in agreement on that? Okay. Because it's really not if they're gonna do it, they're gonna do it as a function of requirement. I think they've been receptive of the abutters or the property owners in the near area who commented, so, okay. You need a minute, or you got it?
I think I have it.
Okay.
I'll make a motion to approve application ZBR 2401 for a dimensional variance by Donna Corvo of 107 Panoma Street for property located at 566 Providence Pike. This is lot AP008, lot 147. The owner of the property is Ms. Janine Lemieux. The applicant is seeking relief from section 5.5.1, district dimensional regulation of the North Smithfield Zoning Ordinance to have less than the required 200-foot frontage and width. The applicant would be constructing a 5,000 square foot single-family dwelling.
Good. Second, we have a second, Mr. Marcantonio. You got all the numbers right, the 107, the 566, the lot numbers you confirmed? Okay.
Yes,
And we
I
have the
do.
relief requested, okay. Do we need to read it again, or are we good? Everyone's good?
That sounded like English to me.
Yeah, okay. We can have a roll call vote, Madam Secretary.
Mr. Najarian?
Yes.
Mr. DeZiel?
Yes.
Mr. Marston?
Yes.
Mr. Marcantonio?
Yes.
And Ms. Benoit?
Yes.
Oh, best of luck. And with that, we have a motion to adjourn. I can't find my.
I'll make a motion to
Do we have anything
adjourn.
else?
Second.
Second, all in favor?
Aye.
Aye.
Have a good night.